Hi, Assalamualaikum madam. My name is Anur Muhammad Luqman Hakim bin Anwar and my metric number 054461. So our group will present about topic patenting of transgenic animals and the Human Genome Project based on US legal stance. So this is my group map. For introductions, molecular biological research and the industry sector is its bound biotechnology are likely to be a primary scientific driving force for the discovery of new drugs as we enter the 21st century. The potential impact of the molecular genetic on the discovery of new therapeutic entities is significant. The government grant patents which have a legal foundation in 15th century Venetian law on the premise that patent induce inventors to contribute something useful to society by offering exclusivity in exchange for the public disclosure of the invention. The modern justification for a patent system is based on the social contract between an inventors and society, in which society has access to inventors' creative endeavors, and inventors receive the exclusive right to develop and use the invention as in inducement and reward for their contribution. So, in the United States, the Patent and Trademark Office, or PTO, of United States Departments Commerce make the initial decision to approve or deny a patent, and US statute mandate that an inventor must clear three major barriers before the PTO grant the enforceable patent right. For a brief history of patents, intellectual property rights were firstly protected in the Middle Age in Venice when master craftsmen issued prohibited challenge from reformer apprentices for a period of 20 years. This law had vastly different economic to consequences for master craftsmen's apprentices and the general public. To protect the master breeders' intellectual property, early breed societies were formed and pedigrees were monitored. The U.S. Patent Act of 1790 is widely regarded as the first modern patent act. In 1791, France passed similar legislations that patents related to living matter are relatively new. The Plant Protection Act of 1930 in the United States was the first specialist patent law applied to a living organism, and it provided what is now identified as a plant breeding right, or PBR, to propagate new varieties through asexual methods. In France, a similar law known as UPOV was enacted in 1961. The Plant Variety Protection Act of 1970 expanded protection in the United States to include sexually reproduced plants. In Europe, the UPOV was revised in 1991. This law established two principles, which is breeders' right, which allow breeder to use protected varieties without the owner permission, and next the farmer privilege, which allow farmer to collect and use seed from their crops. For the downing and blossoming of the molecule age presented significant challenge for the protection of intellectual property related to living organisms other than plants. A French company was rejected a patent in 1975 for a draft egg laying chicken head produced by a process involving cell linkers recessive gains. So in 1980, based on the case Diamond against Chakrabarti, the United States Supreme Court held that anything made by man under the sun is patentable. The patenting of genetic engineered bacteria that destroy all life was at issue in this case. In 1987, the U.S. Patent and Trade Office issued a statement stating that non-human molecular organisms that were there not naturally occurring could be patentable. This was quickly followed in 1988 by breakthroughs patent on the so-called Harvard mouse, which was engineered to be cancer-prone. Similar laws were enacted in Europe, allowing the patenting of animal and animal-related inventions.
Hi, my name is Nik Shohada binti Nik Adeline, and my matrix number is 056695. So today I'm going to present about the Human Genome Project. What is Human Genome Project? The Human Genome Project is an international research project to map all the DNA in a human cell. This project is not just the effort of sequencing the entire human genome. The project's substantial objective is to develop 147 maps of human chromosome that consist of closely spaced DNA markers along every chromosome, which took the scientists 13 years to complete the project. Next, the project shows the significant development of technology for DNA sequencing and also involve funding for extensive research of model organisms like yeast, bacteria, and flies. Another project that involved the human genome was the Human Genome Diversity Project, which focused on exploring human genetic variation, both normal variation and variation responsible for the inherited disease. This project requires examining the DNA of unrelated individuals from 400 to 500 historical population worldwide. This project aimed to answer the researcher curiosity of how the human variation evolved or to what extent can human genetic diversity explain variation in disease risk. The conflicts over patenting human DNA. The idea that genes can be owned is unethical to those who see the human genome as our common heritage. One particular concern is that patents make the cost of genetic tests and genetic therapies unacceptably high by stifling competition. Another fear is that genetic patents may inhibit biomedical innovation by blocking scientists' access to genes and genetic materials that are essential to research. The Human Genome Diversity Project also raises the issue of intellectual property rights for individuals, researchers, and countries. People have highlighted this issue as many of the population targeted for the DNA sampling are from developing countries. They have already expressed their concern regarding DNA patents, international justice, and resource allocation issue. DNA, DNA patents according to US legal stand. In Diamond against Chakrabarti, the US Supreme Court allowed for the patenting of biotechnology discoveries. The issue in this case was whether a genetically modified bacterium was patentable. In a 5-4 ruling, Supreme Court decided that anything under the sun is made by a man is patentable subject matter. Debates regarding patenting non-human living entities and human DNA sequences have raised concern about patenting human organs. The main question on the dispute over genes patent has been whether the discovery of a gene or sequence of DNA would qualify as an invention under Title 35 of the United States Code, which lay out the requirement for patent to be fulfilled. In 2013, the case of molecular pathology against Myriad, the Supreme Court of United States ruled that DNA is a product of nature prior to Section 101 of the Patent Act. Thus, human genes cannot be patented in the United States. The court determined that patents cannot be granted but gave exception to synthetic genetic material. The general rules are that natural laws, natural phenomenon, and abstract ideas are not patentable. The Human Genome Project. After the project completed in 2003, all human gene sequences were in public domain and therefore prior art. One of the first principles established by the Human Genome Project's leader was the DNA sequence generated to be made freely available to the public. This policy was introduced in the Bermuda Principle of 1997, stated that all DNA sequences should be put into publicly accessible database within 24 hours of generated.
Hi, Assalamualaikum and a very good day. My name is Amir Zafri bin Ahmad Tramizi and I will be continuing in presenting on the part of the animal transgenic. Okay, what is animal transgenic? A transgenic animal has had its genome altered by the transfer of a gene or genes from another species or breed. Transgenic animals are routinely used as biomedical research in model in the laboratory. Then, moreover, the transgenic animal farm also being researched to produce large amount of complex human protein for the treatment of human disease. These therapeutic proteins are currently produced in mammalian cell-based reactor, but The process is very costly. A less expensive option would be to find a way to produce recombinant protein in transgenic animal milks, blood, or eggs. So far, only 2 biomedical products have received regulatory approval. There are many inventions have improved to fulfill the capacity and demand. This modernization also affected the farming industry, which there are people who invented the technology to improve the production to meet the demand that increasing day by day. In the United States Patent and Trademark Office, the PTO government granted the first patent for a transgenic animal in 1988. Many of our patent applications fall under the broad category of biotechnology, and the US Supreme Court has established guidelines that apply to this technology. And then in the case of Brenner and Manson, this is the US case. Okay, the court had made it clear that patent utility implied usefulness, not just any invention not positively harmful to the society. Moreover, the court also expressed the reservation about a monopoly on compound with unknown functions, and it stated that the utility must go beyond proving that the product is the result of scientific research. The animal breeding technologies that may require for intellectual property protection include but are not limited to statistically methods for genetic improvement, DNA makers for genetic improvement, transgenic and clone animals, and method for producing them, new methods for measuring traits, methods and identifying animals, computer software and other written materials. And then the Gen Farm has two NIH grants to develop human antibodies using the transgenic animal technology for use in antibody based on the therapies for immune and cardiovascular disease, inflammation, allergies, and cancer. There are companies that created and care for transgenic animal and granted patent on the animal. And then basic researchers who want to use transgenic animal in their research must purchase the animal from private companies that produce them at a relative high cost. The Animal Welfare Act (AWA) is the primary federal legislation in the United States that governs animal property. The AWA is widely regarded as having failed to achieve its goal of developing and enforcing federal standards and regulations for the humane treatment of non-human animals. And then the AWA also seeks to protect any live or dead dog, cat, non-human primate, genuine pig, hamster, rabbit, and other warm-blooded animal used or intended to be used for research, teaching, testing, experimentation, or exhibition purpose, or as a pet. And then lastly, although the patent protection is not available for clone or transgenic humans, but it is available for non-human transgenic animal with human genes sequence engineered into them. It remains to be seen how far human material can be engineered into the transgenic animal. That's all from me.